flexibility. And what he suggested in the report was that the exceptions and limitations that exist currently in the law in this country had become somewhat unbalanced and were rather inflexible and ought to be changed to take account of the way in which society had changed underneath the law. In brief, what he suggested that we needed some new exceptions and limitations. So he suggested that we should have one for parody. We don't have permission, so we don't have free use in relation to parodies. He also suggested that we should have an exception for format shifting, which would allow us to move our music onto our iPod or whatever, because at the moment, theoretically, that remains unlawful. And he also, in a sort of wild and slightly hippie moment, suggested that we needed an exception to cover what he described as transformative uses, so any sort of use of a copyright work which transformed it and turned it into something new. He also, at the same time, suggested that a number of the existing exceptions in our law had failed to do their job properly. So in relation to exceptions that teachers are allowed to make use of in their teaching practice, he said that these should be modified to take account of the fact that education is now delivered via distance learning and via things like digital whiteboards, for example. At the moment, the use of copyright works in those contexts is of questionable legality. It's unlawful under the Act. He also, and this is very important to the British Academy's remit, suggested the extension of the exception that allows people to use works for the purposes of research and private study. As the law stands at the moment, those exceptions only apply to dramatic, literary, artistic and musical works, the core Berne Convention copyright works. He suggested in a world of film studies and scholarship in relation to music, we needed to extend those exceptions to cover films, sound recordings and broadcasts. And he also made certain recommendations in relation to the powers that libraries and archives have to preserve those sorts of material for future generations. So those recommendations were made really relatively swiftly. The Gowers report was delivered and it was presented to government. And to date, government responded with 2 consultation documents and processes, and culminating most recently in a concrete set of legislative processes. Legislative proposals for change. And it's on those proposals that I want to focus, because whilst they do many of the valuable things that Gowers was suggesting, they are, from a user's perspective, also rather disappointing in certain respects. So firstly, none of the proposals to introduce new exceptions were taken up. That is, no parody, format shifting or transformative use exceptions. The government has proposed that the alterations to our existing exceptions be pursued, but in many respects, the actual proposed changes are rather narrowly drawn. So, for example, we have developments in relation to educational use, but those particular exceptions only apply in any event when there is no licensing scheme in place. So if the publishers of those particular works are willing to license the works in that area, then a license must be taken. The extension of the exception for research and private study to cover sound recordings, films and broadcasts will no doubt be enormously valuable and brings things up to date, but it only applies in relation to users who have some bona fide connection with an educational establishment. And that's not a constraint that applied to the defence previously. In relation to libraries and archives, we get very valuable extensions in the exceptions and limitations allowing preservation of works, but in all reality, those have a very limited impact upon right holders. Overall, from a user's perspective anyway, one is left feeling slightly let down. In fact, in this respect, the legislative process rather mirrors the progress of the Digital Economy Act, where initially we had, in a sense, punitive aspects, which we can argue the rights and wrongs of those, but they were also accompanied with more liberalising aspects in relation to orphan works and in relation to licensing. Of course, when push came to shove, we keep the punishment, but the liberalising aspects fell by the wayside. And really it seems to me that it's possible to make a reflection on this process, because what it seems to be increasingly difficult to do in the policy environment that we find ourselves in is to justify free uses of copyright works. This somehow, the idea that people should be allowed to use a copyright work without payment seems to be something that is increasingly falling out of fashion. And to an extent, I'm sure that this is undoubtedly a reflection of broader social and cultural movements. I mean, one only has to think of what's happening in relation to universities and fees and so on to see that this perspective is a much broader perspective. But also, to a very important extent, it seems also to derive from concerted making of their case by right holders. And in the latter part of my presentation, I just want to focus on two specific arguments that have been made very often in this reform process by those arguing in favour of right holders. And both of these arguments strongly militate against the acceptability of people being able to use copyright works without paying for them. And the first of these, and if you look at right holder submissions to these consultation processes, you see very frequent mention of this idea. And this is the idea that copyright is protected as a fundamental or human right, and therefore any incursions on it should only be permitted in exceptional circumstances. And the second, which is less readily comprehensible perhaps, and relates to this rather abstruse three-step test, which is an element of international copyright law. If I just pause for a moment to explain what the three-step test does in relation to limitations and exceptions. This is a kind of an overall set of conditions that all copyright exceptions and limitations must pass if they're to be allowed into the law effectively. And that's a gross oversimplification, but it is to an extent true. The three steps are that an exception must be a certain special case, it mustn't conflict with the normal exploitation of the work, and there must be no unreasonable prejudice to the legitimate interests of the author or the right holder. Rather vague, but apparently commendable. What's happening though is that increasingly right holders are arguing that the second step of that test, that is that there should be no conflict with the normal exploitation of a work, means that exceptions should not be permitted in any circumstances where a copyright owner does currently or could extract a license fee for their work. Now, in a digital environment, that of course is almost all circumstances, and that is actually the argument which is made in some of the submissions to the consultation process. It is really, it's almost a mantra that's repeated again and again and again. You cannot extend this exceptional limitation because to do so would conflict with a normal exploitation. If we accept that argument, then from a user's perspective, we have to accept the inevitable shrinkage of the scope, the sphere within which free use of copyright works can be made. Now, there are various reasons for which I would argue that both of those arguments, advanced on right holders' behalf, are significantly overstated and can be met with counter-arguments. But it's important that these counter-arguments are actually made, because they're not being made in the consultation process. And it seems to me that they're going quite a long way towards fostering an environment in which it will be difficult ever for policymakers to extend the scope of the available free uses of copyright works in more dramatic ways than the relatively small adjustments that we see in this reform process. Thank you.
Thank Thank you, Jonathan, for that